Yes.
My Lord, I appear together with Mr. Crowe for the appellant, and my learned friend Mr. Cosmin appears for the Financial Ombudsman Service.
Yes.
May I start with an overview of Ground 1, which concerns the interpretation of the Cobb's Rule 3.5.3 in the FCA Handbook,
Yes.
which your Lordship will know is called the Client Classification Rule. And as you'll have seen from our skeleton argument, the Ombudsman decided that the appellant had failed to comply with this rule, and that decision was upheld by the judge. Now, my Lord, to be clear, we are not challenging the Ombudsman's jurisdiction.
He was, in fact, a consumer, and you accept that, therefore, the FOS rules apply.
Indeed.
Yes.
And it's common ground that the Ombudsman had jurisdiction to do what was fair and reasonable.
Yes.
We fully accept that the Ombudsman, therefore, had considerable discretion.
Yes.
But nonetheless, we say that there were limits on the Ombudsman's decision-making powers. First of all, the Ombudsman had to act rationally in the public law sense. And
yes.
Secondly, to the extent that it was necessary to apply a provision of law, he had to do so correctly. And I rely on the Assurant case, which I'll show you for that
yep.
proposition.
Yep.
Now, on this appeal, we submit that the Ombudsman either misinterpreted the client classification rule as a matter of law, or that his application of it was irrational. So he made an error that is reviewable by this court. And may I just turn straight to the rule, which I know you will have looked at in pre-reading. It's either in our skeleton at paragraph 20 or in the authorities bundle. I don't know which you would prefer to work from.
The authorities bundle for me.
So it's in the authorities bundle at tab 23, page 561. That's the second one.
These rules are regularly updated, but this is the form at the time.
That's correct.
Yes.
Sorry, you gave us the tab. And
It's 23, my Lord, and it's page 561 within that.
Thank you.
And in a third of the way down, you'll see the head elected professional clients. And so just standing back, first of all, in very broad terms, the purpose of the rule is to allow non-professional customers to be treated by a firm as a professional client if they are capable of making their own investment decisions and understanding the risks involved. And my Lord, that's a crucial point, because the rule only comes into play when a customer seeks to be classified as an elected professional because they want to invest in more sophisticated products and therefore have the opportunity for a higher reward but with higher risk.
And so, I mean, you say that the fact that somebody is not in the industry, i.e. is not a professional, is of itself of no particular importance if they are filling in a form asking to be treated,
Exactly
electing
right.
to be treated as a professional.
Exactly right, because a distinction is made between what's called a professional per se client, and those tend to be authorised entities, trustees and so on, and then elected professional clients, with the word elective being significant in the title. And you start...
What is a per se professional client?
So, my Lord, if you go back to page 560,
Yes.
you'll see the definition. There are two categories under Clause 3.5 of professional clients, and they're either a per se professional client or an elective professional client.
Yes.
And the per se professional clients are listed, as you see on page 560, and broadly are authorised entities and or large undertakings, C&C partnership, and trustees BE. And over the page 561, you'll see government or another institutional investor.
Yes. So for them, if you're a per se professional client, you don't need to say anything other than I'm sufficiently large to look after myself.
Exactly.
Whereas elective professional clients, you need to go a bit further.
You do.
Explain your experience, etc.
Exactly right. And you can see that it starts with what is a permissive rule. So a firm may treat a client as an elected professional client if it complies with 1 and 3 and where applicable 2.
So that must mean you can't if it doesn't.
That's right. But even if, I assume the word may still gives the discretion that even if it does comply, you don't have to.
Yep.
So it follows from this rule, and I'll work through it, that a firm is allowed to classify a customer if the procedure in the rule is followed and the requirements met. And the procedure essentially requires the customer to be made aware of the protections of a retail client that they will lose, and for the firm to be reasonably assured that the customer is capable of understanding the risks and has sufficient wherewithal, essentially, to engage in more sophisticated trading. And I'll show you precisely what's required, but that's broadly the requirement. So the first test is called the qualitative test, and you see that in the definition of subparagraph 1. And it requires the firm to undertake an adequate assessment of the expertise, experience and knowledge of the client that gives reasonable assurance, in light of the nature of transactions or services envisaged, that the client is capable of making his own investment decisions and understanding the risks involved. So the assessment and the assurance is to obtain the assurance and assessment that the client is capable of making his own decisions and understanding the risks. Now, may I make 3 points in relation to this first test? The first is, it's not a high bar. The words used are adequate and reasonable, and those words must, in my respectful submission, be used to lower the standard required, because the rule could simply have said the firm undertakes an assessment and that gives assurance. And
well, adequate assessment is a higher bar than an assessment.
Except, my lord, if read with assessment that gives an assurance, I completely agree with you, in its own it would, but read as the phrase, an assessment that gives an assurance would be almost in terms of establishing.
I see.
But are you just rephrasing your point that the firm doesn't need to get the right result?
Indeed. Exactly.
I mean, that's really what you're saying.
That's what I'm saying. That's what
you're saying is you can pass this test even if the answer you come to isn't
factually correct,
viewed with the benefit of hindsight or otherwise correct.
Exactly.
I'm not sure. This may not be the right moment to deal with it, but I'm not sure that the Ombudsman ever said you have to get it right. I think the Ombudsman said there was enough in the form to put you on inquiry. You should have made further inquiries, and if you had made further inquiries, because the professor was not in fact experienced, you would have been told. You would have uncovered that. So I didn't read the Ombudsman's decision as saying you had to get it right.
So, my lord, what we would say is you're right if you frame it like that, but if you look at how that came about, the Ombudsman having started off in the position he had to have established what the facts were.
Yes.
Having established that the facts were something different to what was claimed in the form, he then said, aha, he wasn't an elected professional, and if you had done more, you would have found out.
I see.
So that's our case on it.
Thank you.
And textually, just going back to my Lord Justice Snowden's point, the reason I've made this point is what is not said here is that the firm must establish. And that's relevant because I'll show you some cases in due course which looked at the predecessor rules, one of which hasn't had an equivalent in the update, one of which used the words must establish. And here, it doesn't say you must establish, it says that you're conducting an assessment adequately to give you an assurance. And in a sense, you can see why, because query how you could establish as a matter of fact that somebody is capable.
You could have just put the risk on the firm. however reasonably they've acted, if they get it wrong, they get it wrong. But you say that's not what this
That's
rule.
not what's required.
That's not what this rule does, I guess.
And if it was required, it would have put this in more definitive language.
Yes.
The second point I was going to make on this first rule is that there's no stipulation as to how the adequate assessment should be undertaken. And so the firm has the discretion to make an assessment however it sees fit in order to obtain the reasonable assurance required. And that's relevant, my lord, because one might suggest that the information provided overall may require different approaches to be taken to different individuals. The third point is, my Lord Justice's Snowden's point, is that the rule doesn't require a firm to obtain proof of what is told by a client. And that's why I say the firm is simply seeking to ascertain whether the client is capable of making their decisions and understanding the risks involved. And part of the inquiry is checking that they have some relevant experience and can afford to trade at a higher risk-reward level. And we see that when we come on to Lim 2.
I mean, you say that the firm isn't required to ascertain the truth of what it's told. It might be if what it's told is on its face crying out for some inquiry and response. I mean, it depends.
It depends, and that's what we would say. That would come in then, therefore, of it not getting reasonable assurance, rather than having to establish the truth or having proof.
I mean, to say the firm is not required to ascertain the truth of what it's told, I mean, I think what you're saying is the firm is not required as a matter of course to ascertain the truth of what it's told. But
it has to do sufficient.
But it can't, as it were, simply accept what it's told at face value blindly.
I accept that. The word blindly is the important point, because I will show you some case law to suggest that certainly the firm can accept what it's told at face value, but I do accept that if a firm is put on notice of some issue, then it couldn't, I would suggest, be reasonably assured.
There is also the word adequate. You said a moment ago there's no stipulation as to how the assessment is to be undertaken, so it's up to the firm. Yes, but it has to be adequate, which suggests some objective standard. They couldn't just... I mean, adequate isn't whatever the firm thinks is adequate, it's whatever is in fact adequate.
I would agree with that. The test is obviously an objective one,
Yep.
so I accept that. But it doesn't suggest that, for example, and the relevance at this point is to the tick box point.
Yes.
It doesn't say here you can't use certain types of form, and it would be a matter for the Ombudsman and this court, insofar as the decision is reviewable, to assess what adequate means.
In assessing what's adequate, you'll at some point come on to whether there is guidance provided, MiFID guidance, for example, or other guidance provided as to flesh out the concept of adequacy.
Not that we are aware of that would be relevant to this file. So we've just taken, all I have are cases on the predecessor rules, and those I'll show you.
Okay.
And, my lord, going on then to Lim 2.
I mean, it's curious to use the word adequate. It's a bit of a fudge because it's essentially saying it has to be good enough.
That's right.
Is 3.5.6 relevant here? A firm must take all reasonable steps to ensure that the client satisfies the qualitative and, where applicable, the quantitative test. I'm not sure because it starts off before deciding to accept a request for recategorisation.
That's right. So if there is, they've already categorised in some way.
I see.
Yes.
So that's not a general. That's not generally applicable.
No.
I see. Okay. Thank you.
And my lord, the second limb is the quantitative test. And you see that in relation to MiFID business, in the course of that assessment, at least 2 of the following criteria are satisfied. Now, that's in the course of the adequate assessment, and it's to the reasonable assurance standard.
This is MiFID, is it?
This is MiFID.
MiFID business.
So, yes, so we do have to satisfy this test. on this appeal and showed that it was. And then you see little b, the size of the financial portfolio exceeds 500,000. Well, that's binary, it does or it doesn't.
And in this case it did.
And in this case it did. And then you have A and C, and on this case it's A that would be relevant. So the client has carried out transactions in significant size on the relevant market at an average frequency of 10 per quarter over the previous 4 quarters. And then,
and so and I think it's right. You say that the mere fact that C is not satisfied on the face of it, because the professor was an academic, is not anything that would put you on inquiry. It just means that C is not satisfied. Therefore, you need to look it up.
that's exactly right. And one of the points I'm going to be making, which Your Lordship's obviously picked up from the decision, is that the Ombudsman seems to have been influenced by the fact that the professor was in education rather than financial services, and we say that that wasn't a relevant consideration because C was never the point.
Yeah, in other words, you can't treat non-satisfaction of C as putting you on inquiry as to A or B,
Exactly
or
right.
anything else.
Exactly right. And then the third limb has to be satisfied, and as far as we're aware, there's no dispute here that the procedure was not followed. So the focus is on the first 2 limbs. And just again, standing back, obviously this is a rule that simply allows an individual who's got sufficient awareness and wherewithal, if I can put it colloquially in that way, to then go on to, if they wish, trade more sophisticated stocks. So one can see that there's got to be some degree to which this rule is an administrative rule of permitting clients to trade stocks, rather than, we would suggest, some deep dive inquiry. And there's got to be some degree of looking at the purpose of this, which is allowing somebody to do something they want to do. There's got to be some degree of balancing, we suggest, between the protective aspects and the administrative burden.
Can I go back to limb 3? I know there's no dispute about it, but can you show us the document which was signed, which does all these things?
Yes, I'm going to come on to show you all of that, if I may.
Yes.
And because I certainly want to see exactly how this came about. Before I go to that, which I'm coming on to very shortly, may I just summarise what we say the errors of law were in the interpretation by the Ombudsman of the client classification rule.
But before we do that, I noticed that these rules contain cross-references to MiFID, which I take it as a directive.
Yes.
Do we get any benefit from looking at the directive? Is anybody
I don't think
proposing to look at the directive?
I don't think you do. We've covered the relevant background to how this rule came into play in our skeleton. And I was going to show you the general jurisdiction. It starts at paragraph 11 of the skeleton.
Yeah. Well, if you don't think we get any help from it, then we won't look at it.
I don't think we do, but I will ask my learned junior to double check that in case I'm not.
Thank you.
So, my Lord, we say there are 3 key areas of law in the Ombudsman's interpretation of the Cobbs rule. First of all, the Ombudsman failed to appreciate that the only relevant issue under the rule was whether the firm complied with the requirement to undertake an adequate assessment, giving reasonable assurance. So the issue of whether the professor in fact satisfied the 2 tests, particularly when assessed with hindsight, wasn't the correct approach.
Sorry, can I ask you to wind back and actually tie this to something in the Ombudsman's decision? So I've got, in a sense I can hear and write down what you're saying, but can you actually show us where the references first?
I will show you all of that. I was just going to outline what we said the errors of law were, and then I'll show you everything if I may.
Yep, okay. Do you want to have another go at that one then? Because I just wasn't quick enough to keep up with you.
What we're saying is that we can see from the approach the Ombudsman took, which I will show you, that he failed to appreciate that the only relevant issue under the rule was whether the firm complied with the requirements to undertake an adequate assessment given reasonable assurance. And the issue of whether Professor Wilcox in fact satisfied the test was irrelevant, particularly when assessed with hindsight. And I'll show you the decision and also the case of Wilson and MF Global, which we say is instructive on that point.
Can I just ask, at some stage in the proceeding, if they found the Ombudsman in any event that it was inadequate, taking that other matter out, they'd in fact go on to surely at some point consider whether or not he was or wasn't, as it were, sufficiently experienced to be an elected professional client for matters of loss, would they or not?
They may or may not have done, because if the answer was, as the assessment was inadequate, therefore he should never have been categorised as such, therefore he wouldn't have been able to trade.
I see, therefore it was irrelevant.
Therefore it's irrelevant,
Yep.
we would say, on I think, the case that's being advanced. So, but I can see, my lord, you're right, in some cases one might have to, but we would say in this case it wasn't relevant. The second point is, a second error, was that the Ombudsman wrongly imposed a requirement within the rule to obtain supporting independent evidence of factual statements made by the client in signed documents. And the third error was, as a consequence of the first and or second errors, the Ombudsman gave no weight to the clear and unambiguous signed representations of fact made by the professor.
On the second one, are you saying that the Ombudsman imposed a requirement, he read the rule as imposing a requirement in every case, or are you just saying that he wrongly imposed a requirement on the facts of this case?
So I'm saying the latter, but I think he may also have found the former.
So I thought you were talking about errors of law at the moment.
Yes. That's because the client was signing the document, so that's why I'm saying it's this case and not. So you're right. So in any case where the client signed the documents.
Can you just repeat what you said about the second proposition?
Yeah, that's if I may ask at sort of slightly more dictation speed, because I'm writing this down, because I don't think we've got a transcript. So
My apologies, my lord. The Ombudsman wrongly imposed a requirement in the client classification rule to obtain supporting independent evidence of factual statements made by the client in signed documents. And in answer to your lordship's question, I think it probably is both.
well, you're saying, I think to make it an error of law, you'd have to say that that was something which the Ombudsman treated as a requirement in every case of the rule,
I think he did.
rather than just saying he got it wrong on the facts of this case.
Yes, that's right.
Because at the moment, as I understand you, you're still in errors of law.
That's right.
Yeah.
So, and what I would say, my lord, to that question is yes, it is in every case. And the reason I was just pausing to your question was I will have to take on the fact that here he seemed to have conflated both the general with the inconsistencies he found. So I'll have to show you why it's a general point, not just an inconsistency.
And sorry, and then the third, we were still.
Yes, and the third was as a consequence of the first and or second errors. The Ombudsman gave no weight to the clear and unambiguous signed representations of fact made by the professor. And, my lord, those errors infected the way in which the Ombudsman applied the rule, because, in answer to my lord Justice Nugee's point, the Ombudsman undertook an investigation of the true position and relied on that in concluding that the rule wasn't satisfied. And he ignored the signed representations given by the professor.
You say work backwards.
He worked backwards. And I don't shy away from this point because we do rely on it, as we're entitled to, I believe. The professor was stated to be on the form, as I'll show you, a professor at LSE for 12 years. And there's no suggestion that was wrong. He was an educated and sophisticated individual who both understood and could reasonably have been assumed to understand the representations he was given.
So a less sophisticated individual who made the same representations might have required more investigation?
Well, they might, but so I can't say that's never going to be the case. But generally, one has to look at, my lord, and I can, in a sense, I'm putting the case both ways, if I may. I'm putting the case in the general way, as Lord Justice Snowden has said, as an error of law, but because under the common law, the appellant here would have been entitled to rely upon representation of the fact, maybe by way of a factual, and leave it there, save in certain circumstances. But that would be compatible with the common law. Here, we say that the Ombudsman just simply ignored those common law rights or failed to give adequate reasons for departing from them. The second way in which I can rely on it is on the facts of this, assuming that the law fails, but I have to then, I accept, show perversity, irrationality. But in relation to that, we would say that when you're looking at the question of adequate assessment, taking into account when you're asking if the client is capable of understanding the risks, taking into account that they're highly educated and sophisticated, is a part of an adequate assessment. And can I tackle finally, before I show you the relevant document, one point head on? The Linear is fully aware of the fact that the Ombudsman is not obliged to apply the common law. So we're not trying to trespass on that point, but there are three relevant points to make in that regard. First of all, in applying COBS, the Ombudsman had to interpret the client classification rule correctly, and he also had to apply it correctly, albeit the evaluation of the facts was a matter for his discretion.
That's not a rationality test. That's simply a what does it mean test.
That's a what does it mean test. So that's why we say you can review it.
Yep.
The second point is that if he chose to depart from the common law, he had to give adequate reasons for doing so. And thirdly, in any event, his decision had to be rational and not perverse in the ordinary public law sense. And I don't know if you've seen Lord Justice Lewison's grant of permission. If I can just show the court that. It's at tab 3 of the core bundle. And you'll see that Lord Justice Lewison gave permission that all three grounds have real prospects of success, and in addition, this is a lead case on which other cases depend. Ground 1 in particular raises an important point of principle. And And the principle is the interaction between the common law regarding representations affirmed by signature and the Ombudsman's jurisdiction to do what is just and reasonable. If we succeed on ground one, the two further grounds of appeal will fall away.
I mean, sorry, just going back, I mean, you say ground one is the one that raises the important point of principle. Can you just tell me which bit of ground one raises that point? Is it just the sentence that the judge, as a matter of law, ought to have given effect to the contractual documents in accordance with their true meaning? Is that what you say the contention is?
Yes, and he gave...
That's not quite what you've...
He erred in law in respect of the client classification, whereby he gave no effect to the information representations and declarations therein, both signed and dated. Okay,
so it's a more general point. You say what's relevant, it's just the interrelation between contractual representations or law that would ordinarily apply to contractual representations.
That's
contractual representations or representations?
Contractual representations.
And the requirements of COG.
That's right.
Yeah. Okay.
And the Ombudsman's jurisdiction to do what's just and reasonable, which permits the Ombudsman not to apply the common law.
So it's all just very important, if I can slightly paraphrase.
Well, yes, and there are, I think, 12 cases stayed in relation following this one, and the jurisdiction of the Ombudsman is now used quite extensively, so it is important.
All right.
My Lord, if we succeed on ground one, then the two further grounds of appeal fall away, and they can loosely be called quantum grounds. The second ground concerns the measure of redress ordered and whether it was rational. And the third ground is whether the approach to contributory fault was rational. And those are both on the grounds of rationality. They're challenged. And they may have substantial financial significance because of the other cases following.
And what do we do if we reject ground one, but accept either ground two or ground three? Are you inviting us to make some assessment ourselves or send it back?
I think, my Lord, you have the choice. And we say, I think you could make the assessment yourself because it's possible to do so with the information you have, which would say that going back, but it could be referred back.
I mean, that would depend which of the grounds we're talking about,
I think that's
perhaps.
Right.
I mean, speaking for myself, that the assessment, if we were to form the view that ground one of the appeal failed, ground 2 and 3 were live, the assessment of contributory negligence, if we would decide that should have been taken into account, might be more easily done
That's
by
right.
us.
Ground 3 may be easier for you to do than ground 2.
But I may feel less confident in wading into what type of alternative investment portfolio could have been an appropriate measure, depending on what you argue about.
That's right, although you could direct the sort of measure that you would, or what the parameters are, because you would have to decide in relation to ground 2 why it went wrong.
Yes.
So to that extent you could do it.
Shall we park this for the moment and come back to it?
That's
But I think we would ultimately like to know not only what we can do, but what you say we should do.
Right. I will address you on that. Certainly on ground 3 we say that you should make the assessment yourselves.
And you'll give us a figure or a range of figures.
I can do that.
Yes. Thank you.
And then there is an additional reason raised by the respondent, which is whether the court can conclude if the error had not been made, it's highly likely the result would have been the same for the purposes of section 31(2)(a) of the Senior Courts Act.
Yes, there's been a bit of not very good tempered correspondence on that. What's your position?
So my learned friend and I have, I hope it in a good tempered way, made an agreement
Yes.
So what we've done is that we set out briefly what our case was, which is picking up points that are already in our skeleton. And our position is just simply that if the decision made by the Ombudsman in relation to client categorisation isn't upheld by this court, and he decided the issue differently, then all of his findings are open to question, which that means the highly likely threshold in section 31(2)(a) is not met here. And there are one or two specific points which we've highlighted in email correspondence to my learned friend. We've also, and I'll address it in this order, we've also agreed, if convenient for the court, that I will make my submissions on grounds 1 to 3 up till 1 o'clock, that my learned friend will make his submissions, including opening the additional reason, between 2 p.m. and 3:50 p.m, and then I will have a reply and submissions on the additional reason until 4:15 p.m, and then he has a limited reply on the additional reason if needed for 15 minutes at the end to 4:30.
We normally sit until 4:15.
Yeah.
Yes, but we'll sit to 4:30 if necessary.
I'm grateful, my lord. I'm not sure it will be needed because the points, I think, are quite short. So my learned friend's heard and has seen what points we're making. I don't know that he will need a reply, but it's there if he does.
Yes, thank you very much.
So, my lord, I was proposing then briefly to look at the facts because I wanted to show you the documents that you've requested to see in order to ground the appeal, and I'll pick up some of the legal arguments within that so that you know what points we're making before moving on to the law. And I'll focus first on ground 1. So the facts are covered in our skeleton at paragraph 2, and I'm going to show you, first of all, the origin of the application to Linear, secondly, the key elements of the application and the associated documents, and thirdly, the complaint process as relevant. And I should emphasise, I'm not seeking to re-argue the point, I'm simply seeking to develop the legal arguments in their proper context. So if I could start by asking the court to go to the supplementary bundle at tab 4, please. Page 33. My lord, you'll see that this is an email sent in August 2017. Tab 4, my lord, of the supplementary. And it's an email from Andrew Craig, copied to Robert Craig and sent to the professor. And you can see that the first paragraph obviously refers to a social event that they've attended. And
what's the sport? Sorry, I'm just desperate to know. Is it tennis?
I assume it's tennis.
Yeah.
And I assume he's got some match on Wednesday.
Okay.
He says, I will send you the details that Robert's company run. So I think that's Andrew Craig's son, Robert. And he says, essentially, it's a computer-generated quantitative investment model. It was created for institutions and has been sold to them and others over the last 7 years. They then decided to feed it with funds, and it's open to professional investors as well as friends and family. Now, just pausing there, he's told from the outset the investment was not a standard investment in stocks, rather it's a computer-generated quantitative investment model which is available to professional investors. And the reference to friends and family don't detract from the fact that it's made plain to him that this was not an investment strategy available to the general public. And obviously, given it was a friend's referral as a friend and family, one would have assumed he was easily able to ask any questions about it. It's also important to note that Linear only deals with professional clients, not retail ones. and that's not disputed. And it was a finding of fact made by the Ombudsman, and just for your notes, I'm going to come on to show it to you. It was at paragraph 123 of the decision, and the reference is Core Bundle, tab 16, page 245. And my Lord Justice Nugee asked about 123. My Lord Justice Nugee asked about the documents that Professor Wilcox filled in, and it was the accounts opening form, the AOF, at tab 5 of this bundle. And if I can just show you that. So the purpose of this form was in accordance with the client classification rule, to ascertain the professor's relevant trading experience and history and financial profile, to assess whether he met the qualitative and quantitative tests. And our position is that the form contains specific and focused questions designed to elicit relevant, informative answers about his identity, his employment history, his relevant trading history and wealth.
And just to be clear, this form is not approved or vetted or in any other way, has no input from the Financial Conduct Authority. I mean, do they get to see this in advance? It's not a standard form, it's just a document.
It's a document used by this firm.
Yep.
And its purpose is, though, as you'll see from some of the questions, clearly targeted at.
Yeah, no, I was just simply checking whether it's bespoke or whether it's standard.
No,
but it's bespoke. Yep. To linear.
To linear. And critically, we say the form required the applicant to affirm the information provided with a signed declaration. And so if I can just show you, working through the form, you see at the top, under the heading Account Opening Form, that it's said right at the outset that it's important the applicant provides accurate information because it's going to be used to assess suitability to open an account. And we see that the general information is filled in by hand by Professor Wilcox.
Is there a finding that that's his handwriting?
As I understand it, it's not been suggested, and I think his own representative said he filled it in himself. So it's not disputed that he filled this in.
Thank you.
And you see that he gives his details and his occupation. And as I understand it, it's not suggested that any of that was wrong. Then over the page, you see he provides his bank details and then critically his financial information. And you see that he declared a substantial annual income, net worth, value of the investment portfolio, which obviously met Lim 2.2 of the Cobb's rule. And he ticks that he understands that only risk capital should be invested and that the source of his funds is his savings and investments rather than his employment or pension. So just pausing there before we get to investment experience, what we've seen is a clear warning, the need for accuracy, the fact that he's an educated individual who ought to be capable of being able to read and understand the form and give accurate answers, and that he's said that he has substantial wherewithal, so clearly can afford, as I put it, to enter into trading of this sort. And again, I don't believe any of that information to be challenged as inaccurate. We then come on to his investment experience. And again, just pausing there, when you look through the form, what you see is that the form targets the different categories of investments, and the questions are plainly geared to the Cobb's test because they're trying to establish a significant period of trading, frequency and transaction size, which is going to the qualitative test, as well as obviously the general investment experience. So here we see the question, have you traded in equities? Yes. And if you look at length of activity, 2+, frequency 40 to 80, average transaction size 25+. And significantly, you see the capacity in which he traded, execution only and advisory. So what that shows is that he was saying that he had given his own instructions to trade, not necessarily all advised, that he was capable of making his own decisions, which again is very significant when it comes to his relevant understanding and capability. You then go over the page to contracts for difference.
How is this form provided to somebody, by the way? I mean, is there a finding about how it's a physical form provided by somebody?
I believe it was sent by email, because I'm going to check that, because I remember seeing an email in the bundle.
It's plainly been at some point printed out.
Yes. So there are no specific findings about it, and I don't recollect that about how it was provided. It must have been either provided in hard copy or printed out, because he's filled it in by hand.
Yes.
And that's all we can, and there's no suggestion that he didn't fill this in.
It doesn't come with any sort of guide to filling it in terms or anything like that?
Not that I'm aware of. But again, my Lord, on this point it's relevant to note that this form is only if somebody wants to trade a particular type of product and have a particular type of activity. So one assumes that.
I'm going to. That's a question I'm going to come on to, which is why I started with the question I just did. So
exactly.
I'll wait till, if I may, to ask that. But it's interesting that I'll ask it now. When we get onto the market knowledge and individual objectives section, it talks about explaining the experience and knowledge in relation to the transactions that the account manager plans to execute via Linear. What I just wanted to know was whether there was any document that set out what was planned.
So, my Lord, we haven't got a document that sets out what was planned. There are 2 points to be made. The first is that Linear only traded in contracts for difference, and that's a finding that's been made by the Ombudsman. So it would have been known that it was contracts for difference.
But it only trades in contracts?
Well, it was only doing that at the time. That seems to be the finding.
Even though
it's asking, because this is going to general capability of understanding, and therefore all the experience presumably is relevant. But it only dealt with contracts for difference, and that's what the Ombudsman found. And the second point is that there was quite a debate, and I haven't gone into it.
Was there a finding that the Professor knew that it only dealt... I mean, when we come on to the findings, can we just go back and...
We'll have a look at this, yes. But
I couldn't join those dots.
The second point I was going to say to you is that there was a debate that because he was introduced by a friend to his son's company, Robert Craig, that there was a dispute because Linear said, well, he was in charge of dealing with him and dealing with his account. But the Ombudsman, I'll show you, found that there wasn't sufficient evidence to show that that conveyed any further knowledge to him, and therefore, I don't know how significant it can be in press articles. But I'll show you that. But just taking this form on its face, my Lord, without anything beside it, we say that you've got an educated professor who's applying to trade with this company and clearly knows enough about the company to apply to it and trade. And he is of sufficient wherewithal, and he says that he's got significant experience in trading equities, both on his own account and with an advisor, which automatically will put him into a box of having relevant information. We then come on to contracts for difference, and he says he has traded in those, and again says he's traded for 2+ years, 40 to 80 frequency and 20 lots.
What is a lot in these circumstances?
In my lord, it's how transactions for contracts for difference are measured, and it is a standardised unit of measurement that determines the quantity of the financial instrument traded, and the lot size specifies the predetermined number of units of a financial instrument involved in a single transaction. So it's a standardisation. So the number of lots within the transaction he pits as the maximum. Now, that doesn't mean, because it says 20 plus, it was only 20. It's more than. So he's showing that it's significant trading, and that's why I was going to come on to say.
Put it, my Lord's question, a slightly different way. When you talk about trading in equity, you can see the average transaction size is given in financial
That's right.
numbers, because presumably if you trade, 100,000 BP shares, you can identify the size of the trade. With contracts for differences, by definition, you can't necessarily, unless there are limits, you can't tell anybody what the size of the difference might be.
That's right.
But I'm not quite sure how the concept of lots work.
So lot size, trying to find the best way of putting this, determines the value per pip movement, and for a standard lot, a 1 pip movement equates to a $10 change, and so the lot size specifies the predetermined number of lots in the financial instrument.
But okay, so without wishing to cut across you a second, because I'm certainly not being able to write that down, but somebody ticking the box would presumably either just be ticking it without caring, or alternatively would know what a lot is, because otherwise how would they know? It's a question that I sort of raised before. Was there a accompanying guide to somebody to say, what a lot is and how you should decide which of those boxes to tick?
Well, the reason he would know is because he said he's been trading them, and though that's what he's been trading, you see. So if you didn't know what it was, you wouldn't have been. It would be because you hadn't been trading them. And the reason you're and the way it's, I'm just trying to find a sort of standardised definition of it. To the question, what is a lot? Lots are essentially standardised units of measurement and represent the size or volume of a specific trade. In the context of CFD trading, CFDs are usually traded in lots, with each contract representing a particular unit size of the underlying asset.
Okay, you must have that written down when you've got a definition in front of you from somewhere. And
I have.
Where does it come from?
I've got CFD trading was the definition that I'm using.
CFD trading for dummies.
CFD trading for dummies, indeed, and lot size in trading explained, a complete guide.
My lord, I wouldn't ordinarily rise, but I'm conscious that whichever document this is, we've never seen.
No, I know. I've just this is
and below supplementary bundle 317, in the final tab, the submissions were very clear that there is no evidence as to the number of lots, their size, or what would would be.
Where were you? Supplementary bundle what?
Supplementary bundle, final tab, page 317.
What letter?
At G, my lord. What does your client say the average transaction size, number of lots that they normally, what would a lot be in there? Well, I have no evidence.
Yes, I'm not giving evidence on specifics. I was just explaining what a lot was.
Well, the short position is that below there was no evidence at all as to what was meant by the term lots, and we never sought to obtain it contemporaneously.
Mr. McNeill was acting for Linear.
That's right.
Mr. Mill was actually. That's right.
But I mean,
But the court has to understand what the concept is. So
well, I mean, your point is that whoever filled in the form,
yes,
at least on the face of it, understood the form
yes,
to be able to tick it without asking further questions, because there was no guide
That's
that
right.
accompanied it to explain it to them.
that's right.
So
And
they've either ticked it not caring blindly, or they've
they
made a
understand
conscious
because they've
decision
been trading it.
knowing what a lot is in the context of
Yeah.
CFDs which they've said they've traded.
And my understanding, and I'm not giving evidence on this, my understanding is that a lot is the size, is the way in which you measure size for the reason my Lord Justice Snowden gave. You can't say, because the whole point is you don't know what the difference is going to be. So you don't know what the financial significance of it will be. What you do know is how much you've invested in the underlying asset, which is measured in lots, and that will then show the size of the transaction for the purposes of this form, but I can't, and I'm not trying to give evidence as to what the value
We
was.
don't have a sample contract difference before us.
You don't, but I'm sure we can
Well,
agree on and provide
I mean,
one.
I have a sort of amateur idea of what a contract difference is. It's you get paid or you pay, depending on which way a particular asset moves.
That's right.
But I don't have any detailed conception of quite how the contract is structured and how much capital you have to put up and so on and so forth. Are we going to get any explanation of that, or does it come out of the complaints as to the risks involved, or anything like that?
I think there's one document which might give some information about it, so I can show you. But there's not a sample of the contract, but your Lordship's understanding of what it is correct. And all I was going to say was on the point of this transaction size of lots. The whole point is lots is being used, and I think
Well,
this is
you say it's being used as a proxy for the transaction size.
well, and it is definitely, because that's how it's measured in the market, because you can't give a financial value.
But the Ombudsman said that you could have had a whole number of very small lots.
But that, my lord, we would say he had no evidence to suggest that you would trade in CFDs and £1 lots. All you can see is that on this form, it's the highest category, which would indicate substantial size for the purposes of the test. And accepting this on its face, and it's a separate question as to whether any of this should be tested, but on its face, you have an answer from somebody who you would assume could understand and honestly answer the questions. And he's saying he specifically traded in CFDs as well as equities separately for 2+ years at a frequency of 40 to 80 in the highest transaction size, which he understands. And more importantly here, he also says he's done execution only in CFD trades, so he's not even needed an advisor for some of his trading. So again, this puts him, assuming his answers are to believe, in the highest category of sophisticated investors according to these questions. And in answer to my Lord Justice Snowden's question, he plainly didn't appear to have any difficulties filling in this form so far as Linear was concerned, and they were entitled, given who he was and the signed representations and what he said he'd done, to take this at face value. Now, you see then the questions ticked for fixed income, options and futures and FX. So what you can see immediately is that this is a form that the average person doesn't trade in contract for difference and FX. So it's a form directed at people who have a particularly sophisticated, or assuming that somebody might have a sophisticated risk appetite and palate.
In some ways, you're saying it's the only relevant part to fill in for Linear because that's the only investment they do.
Well, it's not the only relevant part because the test under the Cobb's rule requires you to satisfy yourself that you're dealing with somebody who's capable of understanding.
But you're saying that in fact, Linear only
That's right.
deals with investment.
In fact, but even if he ticked, for example, no, I've never traded in CFDs, that might then have provoked a need to delve further. But showing that he's also got the equities experience shows somebody who's clearly got an experience in investing, and this isn't an ingenue. So,
but I mean, my Lord's question is, I think, I respectfully say so, bang on the money, because in 3.5.31,
yes,
it says the firm undertakes an adequate assessment of the expertise, experience and knowledge of the client that gives reasonable assurance in light of the nature of the transactions or services envisaged, which is what I was going to come back to when you look at the market knowledge of individual objectives. Because I think this question of what were the nature of the transactions or services envisaged is what I was just focused on, because you say well,
well, they were at that time. I'll show you another document that shows that the products were listed generally, but there's a finding that there weren't.
Can I just sort of just going back one tab, just to
yes, tab 4.
Tab 4. Forgive me my sort of ignorance in the field, but is there anything in that which implies that they effectively were offering CFDs?
Well, I think he sent the website, which I assume would have said.
Well, no, I meant just from the email. I know it's not an email from Linear, but is there anything in that which discloses that? It didn't appear on the face of it to me, perhaps
I don't think so. I mean, it's the fact that it's a quantitative investment model shows that it's obviously dealing with sophisticated products. But I couldn't say that that was definitely tied to CFDs. I think the company website would have shown what they were trading in, and that's obviously where he got his information from, and no doubt proceeded. And I completely agree, my Lord, that it's important that the contracts for difference were covered, but the other questions did go to his more general investment, his capability, if you like, of understanding the risk. For example, a company may be satisfied that somebody who's never traded a particular type of instrument could understand the risk given everything else they've been doing. Now that might require further questions, but it may, the information being asked for could be relevant beyond CFDs. What's also relevant, if I may say, is the fact that where the professor ticks no, because they could, the firm obviously, if there was any concern that he might just be ticking yes to everything. But here, the professor does say that he hasn't traded certain things, so he's very specific about what he's done. Now we then come on over the page to the point that's obviously concerning my Lord Justice Snowden and concerned the Ombudsman and the judge, that he said, have invested for 15 years in blue chip stocks. Now, it was said by the Ombudsman and the judge that this statement was inconsistent with what Professor Wilcox declared on page 4, i.e. that he had traded CFDs. And just for your Lordship's note, we addressed this argument in paragraph 38(1) of our skeleton. Now, the essential point made by the Ombudsman was that investing in blue chip companies is not the same as investing in CFDs. And so this statement by itself demonstrated that Professor Wilcox didn't have experience trading CFDs. And that was in the decision at paragraph 50, and I'll show you it, it's in a moment, it's in tab 16 of the full bundle, and it was also in the judgment at paragraph 79. Now, well, that's not correct for two reasons. First, the fact that Professor Wilcox said he'd invested for more than 15 years in blue chip stocks was consistent with what he'd said elsewhere in his form, equities. And he didn't say anything else about what he may or may not have invested in. So by itself, it's not inconsistent.
I mean, I don't think, to be fair, I don't think the Ombudsman said it was inconsistent. It just said, as I understand it, he just said that answer about blue chip stocks doesn't support the answer given in relation to CFDs. It's not inconsistent. It just says it may support the answers given in relation to equities, but it doesn't support the answer given in relation to CFDs. And so I thought what the Ombudsman said is that the firm should have made further inquiries if what was actually planned was trading in CFDs.
The judge referred to errors in the account opening form in her judgment, and it's not clear what was being referred to, but we had assumed that that was being referred to as an error, and it was this that the judge had in mind.
I mean,
So,
if what was planned was trading in equities, then that answer that you've invested for more than 15 years in blue chip stocks would, on the face of it, not raise any concerns,
No.
because that's somebody trading, on the face of it, that certainly must include trading in equities.
we would say,
But-
my lord, it must also include trading in CFDs, and may I explain why?
Right, yeah.
So we say it's actually clear from the complaint itself that one way of investing is to buy in blue chip stocks is to buy equities, but another is to buy CFDs in those companies. And if we go to the complaint, which is in the same bundle at tab 9, I'll come back to the form, but you can see on page 61, this is the complaint made by Professor Wilcox. And he complains about certain trades within this. And I'll just come back to this document, but if I can just meet this point, it's at page 65. And he complains, and this is the document I had in mind when referring to my local Justice Stacey a bit about the trades executed. It's 3.43 on page 65. You see that he complains about certain trades, Edenred, Shell and Peugeot. Now, these must have been CFD trades, and the Ombudsman found, just for your note, and again I'll show you this at paragraph 111 of the decision, is where the Ombudsman found Linear only traded CFDs. So that it's perfectly possible, one can see, to invest through CFDs in blue chip companies.
I mean, if this is the professor writing this complaint, it shows a level of understanding,
It does.
a considerable level of understanding. Was there any finding as to who wrote this complaint?
I will check that. He certainly had James Craig, who is the brother of Robert Craig, assisting him, but there's no suggestion that James Craig was involved in the company or a solicitor. I'll double check that. So, as far as we're aware, this is his own complaint, it's not suggested otherwise. But my point is, and I'll come back to this document because it is relevant, my point is that you can see the three of the trades he's complaining about, and it's certainly Shell, everyone knows, is a blue chip company, and this is a CFD. So it's not right to say that when he said, have invested for 15 plus years in blue chip stocks, that was limited to supporting equities, and we can see that on his own documents.
Forgive my ignorance, is blue chip company a technical term, or is it just an informal term? Does it mean FTSE 100 or something like that, or does it just mean...
I think it does, but can we look it up?
It's just a...
We'll look it up definitely. I've always just used it informally, but I don't know if that comes from a recognised definition.
I would have thought it was just a colloquialism,
Right.
but...
I mean, barristers are occasionally described as having blue chip practices.
Yes.
I don't think that's anything
Magic
other than a
circle.
colloquialism. So, certainly, some of the people I know.
Yeah.
Yes, but taking Magic Circle as an example of Magic Circle firms, that seems to now you would recognise a certain group of firms as Magic Circle. And again, that's a colloquial expression. So I think when you say blue chip, you sort of know what it's meant by it.
Your point is,
You can trade CFDs and invest in blue chip companies. And so, and you can see that on the face of what he was doing. So that's not, there are 2 points. One is that saying this only relates to equities is wrong. And 2, it's not fanciful to suggest that he was referring to CFDs here because in fact, or could have been, because in fact he did actually trade in blue chip companies through CFDs.
I mean, am I right in understanding that in 3.4.3, the complaint in relation to Edenred, Shell and Peugeot is that they should have been traded once to close, meaning that there shouldn't have been an open position, I mean, which is the nature of the CFD.
That's right.
I mean, that's the point. You don't have an open trade, because it's a contract for differences, you have to close the position out.
Yes.
Which is not the same thing that you do when you're just trading equities, because you just either buy or sell them.
That's right, but he uses the word invested, and that will cover both.
Yeah, I mean, these are trades which happened as well after the...
Yes, absolutely right. I'm not suggesting they show that he had in fact traded. What I'm saying is that you can't read his answer simply as limited to equities, and we can see from what he then went on to do that that's not a fanciful suggestion.
Certainly by the time you wrote the complaint,
Yeah.
either somebody who was involved in writing the complaint had a reasonably clear understanding of exactly what trading in contract for differences involved.
Yes, and my lord, obviously approaching this on the footing that he hadn't got any relevant experience is one thing. You can see then that you could interpret it through that prism. But if you look at it before standing back thinking that it's true, he's a professor, he said he's got significant experience on an execution-only basis in both equities and contract for difference, but not in other things which aren't relevant. And he says, I've invested for 15 plus years in blue chip stocks. And that is supported in some ways by the size of his investment portfolio, which is substantial, and his net worth. And the two types of trading, only two types of trading, he says, he's done are equities and CFDs. And there's no suggestion, therefore, that he, on the face of it, that he's not telling the truth, or that he didn't have the relevant experience.
And it's a different point, but I mean, in some ways, saying you've only been investing, you have invested in blue chip, we suppose a rather sort of a cautious, limited approach rather than anything else.
It might just say that you want.
Well, I might be if dabbling blue chip, I think.
Some people just want the best. I don't think it says anything about risk appetite. It's the instruments and the strategies that are more risk appetite. So if we then look at, you say he's trying to achieve growth, and are there any specific risks you wish to avoid? No. That's back on the same column. That's back in the account open form, tab 5, page 38.
And the answer to my previous question is that there is no other document which sets out the transactions that the account manager plans to execute via the investment activity.
No. But, my lord, this is the ability to trade. We're then going to come on to the managed discretionary account agreement. And it's only another document, only once then gets that signed and done that we then get into a discussion as to what it is to trade.
The one point that I think that answer to that question take against you, because that answer to that question or Lily if there is not an inconsistency per se, but a potential disconnect between that answer and that question.
And that's what I'm saying, it's not right. It isn't. Doesn't I've shown you the evidence laid out by documents within Lake 5. So that's what I'm saying, we say that point is right. That's one of the points made. Then the answer that there are no specific risks he wished to avoid is and then, my lord, if we look back on page 38, the point isn't taken against him, I believe, and I just cover it, you can see that he doesn't tick the other fines. But that's not an issue because the claim wasn't a per se professional client. And he did make the application and sign the relevant declaration, which I'll come on to. So you then see the account opening declaration, and this is one of the declaration signed. I confirm that the information provided is true and accurate and may be relied upon by me in assessing whether I need to upheld the fines to be treated as a professional client. So he says in turn that what he said is accurate. You then go over the and that's saying that it's an agreed appendix. So there are two relevant signatures. The main one on the representation is the account declaration, page 38, which confirms the information, and which Linear could have expected Professor Wilcox to understand and act truthfully and responsibly. And then there's the second declaration, which is the confirmation that he's under the rules for the elected client. Now, emphasis was, the second point which emphasis was placed by the Ombudsman was to please ensure to attach appropriate evidence to support categorisation, which is the appendix D. And much of that is made by the Bob, for example, in paragraph 25 there. But it's not because of the really confusing and giving those the addresses in paragraph 14. The first is when it comes to interpreting the FTSE appendix, that is a question of the law. It doesn't matter what's been said here. Secondly, the word appropriate leaves open the possibility that there is no such provision. Here, the message is stated member of the CFP society. I don't need to worry about that. Now, you might need some additional evidence to show a member of the CFP society probably did cause, and one that to check that you're dealing with someone who's got no information about what he's doing, but you can be sure that he is doing he's saying that he's lying. Here, you've got somebody who is clearly sophisticated and has told in terms that he's got extensive experience. And the only reason that he's not. And I'll show you that in a moment. But before I do that,
So is your point qualitative way? Can't turn it off. So is your point in essence the person signing the form, he didn't pay full attention to that statement at the end, didn't really dealt with it before, or didn't think it was fully ticked all the relevant boxes. And the form does say that what he said on the form can be relied upon within their view. That's what he says on the brief.
So if, in another way, if you've taken his answers at face value, what he suggests you're entitled to do, on the basis he was a truthful person, then that was sufficient for us to be satisfied if he'd really traded CFPs in that quantity at that time, and really had done it, he really was a professor, and really had the money he had, then that ticks the boxes. That request for further information is if you think you need anything else, then provide it, please, as appropriate.
So he basically was, you're saying, he explained he wanted to do whatever it is, and there's trades, and he ticked the boxes, and didn't think it was necessary to provide any more information to assist Lydia to assess him in the way that he was asking to be assessed, namely as
Exactly, and that's why it's important to recognise, as far as I said, that what someone's trying to do here is just simply be allowed to trade. This actually doesn't then require them to trade, determine how they trade, how much they trade. It just gets them to basically like legal and that's why the question of concern is this somebody who's vulnerable? And putting it another way, you're trying to avoid vulnerable person who doesn't understand anything losing their money because they haven't appreciated it. And this form, as filled in, would give no indication that somebody is anything other than sophisticated. And can I just show you one form that's in one document that's the Ombudsman? It's the ESMA guidance. It's a tab 8 of this one. And this is, as you see, right at the European Securities and Markets Authority guidance, and it came into force in 2018. So it wasn't actually in force at the time that these trades were conducted, which the Ombudsman did recognise. And if you go to page 59, client classification is start on 58. And you see on 58 under answer 2, a private individual investor may be allowed to waive some of the protections afforded by the conduct of business rules by requesting to be treated as a professional. So that's all that somebody's trying to do, to waive some of the protections for a retail client. They're not obliged to trade. You go over the page, and this is what seems to have influenced the Ombudsman. You have to remind in accordance with the first paragraph, this is looking at the next two individuals. Private individual investors may be treated as professional clients only if adequate assessment, etc. is assured. circumstances, usually the category of products the client intends to trade, a more thorough analysis may be required. It may be required. Now here, this is the very category of trades that they were intending to trade. He said he had extensive experience on. If he had ticked no to that box, or ticked that he hadn't got very much experience, more may have been required. And then you go down to the paragraph starting, in addition. Investment firms are expected to take all reasonable steps to ensure, etc. And it's this sentence that I think influenced the Ombudsman.
Sorry, which paragraph?
I'm on the fourth paragraph, starting with in addition. And it's 3 lines down a little. Whilst investment firms should use their discretion to determine the reasonable steps needed, they should avoid relying solely on self-certification by the client and consider obtaining further evidence to support assertions that the client meets the identification criteria. Notably, when they consider that the documents or statements received from the client are not sufficiently conclusive.
So just to be clear, I asked you earlier about MiFID. This is referring all the time to Section 2 of Annex 2 of MiFID, which clearly was in force.
That's because at this stage this was in the same terms as COPS. So I don't think it would show anything different.
Right, so at Section 2 of Annex 2 of MiFID 2.
You can see the test is exactly the same.
But this guidance, there was no predecessor to this guidance in existence at the time of the entry into this.
Not that we're aware of, and the Ombudsman relied on this and then said, just showed you, it wasn't enforced, but I think market practice was the same. So that's what he said. Plainly, some of these questions were in place at the time. Question 1 was certainly in place. That's when it said, it looks like that question 2 and question 3 may have been added in May 2018. I think this just came into force, this guidance. Is that what you were asking, my lordship?
Well, question 1 is said to have been last updated on the 3rd of October 2017, which suggests that question 1 guidance did exist at the time, in December 2017. But question 2 and question 3 either weren't in existence or hadn't been updated.
Yes, but all I can tell you is that this was published in May 2018 in relation to question 3. And so you're right that there may well have been guidance on other provisions, but there was nothing cited to the Ombudsman, and he just simply said he assumed it reflected market practice, even though it came into force later.
Can you say that he was not entitled to?
No, I don't. I think originally...
You're just saying this may have been...
This may have been interesting, and what I was going to say is actually properly read supports my interpretation. So I was going to come on to that. There are 4 points why I say it supports my interpretation. But first of all, the guidance records that the firms have discretion to determine how to carry out their own assessment. Secondly, you see from the top of page 60 that it's all directed to the client's understanding. Thirdly, back on page 59, self-certification is described as assertions that the client meets the identification criteria in the rule. And we address this point in paragraph 34 of that skeleton. Assertions by the client, for example, they meet the sufficient experience and expertise. So if the client said, I have sufficient expertise to understand the risks, that I can see would be impermissible. That is entirely different from the form which established a wide range of underlying facts which only the professor could tell Linear, which were relevant to the issues in hand: experience in trading, type of trading, length of trading. That's not self-certification, that's saying, here's the material information to go to my knowledge expertise. And that's different from what they had in mind here as impermissible. But fourthly, and perhaps the most crucial point, even in that event, this guidance makes clear that a firm should consider obtaining further evidence, notably when they consider the documents or statements received from the clients are not sufficiently conclusive. So we say this supports our interpretation that one only needs to go behind detailed information and representations if they are not sufficiently conclusive.
You say self-certification would be somebody who just ticks a box on the form to say, I certify I meet the requirements of COB 3.5.3.
Or I certify I've got sufficient experience.
But providing the sort of detail in those boxes, you say isn't self-certification, that is further information.
That's further information. And separately, in any case, even if it was sort of self-certification, it's only if their answers aren't sufficiently conclusive, and we say they plainly were, if you take what's said on its face, which is what was required. Now, my Lord, I'm conscious of the time, so may I just quickly refer you to the only other document of relevance, which was the Managed Discretionary Account Agreement, which is tab 6 of this file. And these are the terms on which Linear was providing its discretionary management services. And just to show you, this was where the charges were set out in clause 7 on page 46, as well as a limit on liability, which isn't relevant to ground 1 but could be relevant to other grounds.
Just out of interest, at the bottom of page 43, I don't know where you were going to go. Have you gone past page 43?
Yes, I have.
So at the bottom of page 43, it says our services are limited to providing a discretionary investment management service and advice in relation to bonds, shares, and derivatives.
Yes.
So
derivatives include CFDs.
Right.
Yeah.
Yeah, I know CFD is a derivative, but that also suggests that they were going to do something other than CFDs. So it goes back to my point as to what was envisaged with the professor.
I was going to show you that if you go to page 49, you'll see that they talk about portfolios, as you can see, and we know that there was a complaint about the Pembroke portfolio, and they're saying products traded here, so they were showing all options. As a matter of fact, at that time, Linear, as the Ombudsman found, Linear was focusing on CFDs. Now, I don't think that's a problem in the sense that there was options, they're getting information about all of it and they're focused on one. But under the terms of the agreement, they can trade others, and the client presumably could trade others if they wished to, assuming Linear was able to do so. And here you see at the bottom, just above that heading, all the strategies will be discussed at length by your investment advisor, outlining the potential upsides as well as the downsides. So when selecting the allocation of capital, it meets your investment objectives. So what I was saying to you is the account opening form and the classification doesn't actually require trading or suggest that you're on your own or off you go. You then have a managed agreement on terms and a client and an account manager. And Professor Wilcox signed this on page 50. Now, my Lord, the original complaint I've shown you very briefly is at tab 9, and I won't take you through it in detail, but there are 2 points to be made on it. 3 points, I beg your pardon. The first is that it shows a high level of sophistication, and on page 69 it's signed saying that the facts stated are true, and so on. That's the second point. The third point is that nowhere in this letter does it complain about the classification or make any suggestion that he did not understand the trades or his own, or had lacked sophistication to make the decisions, or that he didn't understand anything. He simply complains about the way in which his account was managed in accordance with the terms and conditions. And this is after he has traded for a good period of time. Then if we then go please to tab 11, you see that the complaint is brought to the attention of the FOS, and on page 75 you see that he's said to be assisted by a friend, James Craig. That is the brother.
Sorry, just wait. So you're in tab 11.
I am sorry.
So which?
Page 75.
Yep.
This is the complaint form to the FOS.
Sorry. Yep.
And at the very top, you see James Craig, a friend, is assisting Professor Wilcox. This is Robert Craig's brother. The complaint is on page 77, and you can take it from me that it includes no reference to or complaint about professional client categorisation or sophistication. It was first investigated by Geoffrey Patterson, and the first time that the question of client categorisation was raised was a year after the complaint was made. So it's a call of the 19th of October 2020, and you see it at tab 12. And it's about 4 lines up from the bottom. C's rep feels B didn't follow the proper procedure in classifying C as an elected professional client. We then can go please to tab 19.
So it's not been first raised by the FOS, it's been first raised by
James Craig. But it's a year down the line and isn't the handling process, as you see, the length is different. And you then see at tab 19 of how the investigator approached it at 1.1.12 in the middle of the page. I'm going to be asking you here, it's that paragraph under the quotes. And then right at the bottom, if it's the case that Professor Wilcox shouldn't ever have been classified as a professional, it's likely I'll be upholding the complaint on that basis. And then a key letter is in the following tab. So this is from James Craig and says he shouldn't have been classified. That they essentially carried out a self-certification exercise, and he simply filled in some forms with account opening. Number 2, he never worked in the financial sector. And number 3, he remembers ticking some boxes on the account opening form but doesn't remember what they related to. Now, just to tell you, the Ombudsman did not accept Professor Wilcox's evidence in that regard. And obviously the implication of that was that his information about equities was also untrue.
When it said that he didn't write to Linear to request to be categorised as an elective professional, I mean...
He filled out the account opening form, so I don't think that... It's not taken against me. I think that the process was wrong. But they were obviously trying to take whatever points they thought.
But is the point meaning that he didn't write separately?
Exactly.
Okay.
And then after that, further information was requested by the Ombudsman, wasn't satisfied about why the form was completed as it was. And just your note that was in tab 24. And we see the answer in tab 25 of what was said. And here you are, you were asking me, was there any dispute about him filling in the form? It says in the last sentence, he confirmed that he filled in the form personally.
And that's where he says, he thought they were like shares.
Yeah. And that explanation was rejected by the Ombudsman in his provisional decision on the 5th of August, which we find at tab 30. And the reason I'm showing you this is that I don't think the reasoning, this finding didn't change in the final decision, although the finding on contributory negligence did. So if you have the start of that at 143, and if we can pick it up, please, on page 146, right at the bottom, you'll see, whilst tick on, they obviously provide limited evidence of actual expertise, experience, and knowledge. I'm not satisfied with relying on a client completing the tick boxes without an adequate assessment. In effect, so and then he mentions the ESMA guidance. And he says, 3 paragraphs down, I think the guidance shows that firms need to be aware of that and not just take information at face value. I think they should have obtained further information. It's not clear what should have been obtained here. And 2 paragraphs down, I think Linda should have appreciated, regardless of any guidance, that simply getting past the ticks and boxes is unlikely to take any steps. So,
You say that's wrong because if the ESMA guidance, you say the ESMA guidance is just simply saying you shouldn't rely on self-certification, but it's not saying you can't rely on somebody making specific statements about the number of trades they've done in certain.
exactly.
And otherwise, what you say that every time somebody wants to become professional, they'd have to, in effect, provide details of all the trades they've actually done.
They may not want to do that eventually, because they can do
That take all reasonable steps, I think it's 3.5.6.
That's right.
I think you said earlier when I asked you 3.5.6 doesn't apply in this situation because it's only a recategory.
So he then goes on to say, look at the 15 years, and says this is the only knowledge and experience he referred to. Well, that's just not right, because he said he'd been trading for 2 years in equities and CFDs. And he then says it hasn't taken account of information in the same form which isn't consistent. That's where I got the inconsistent from, my lord.
Well, I mean, to be fair to the Ombudsman, this is because the account opening form also required Mr. W to provide a brief explanation of his experience and knowledge in relation to the transactions that the account manager had to execute by lineal. That's the box on the left-hand side. He stated this is the only knowledge he was going to refer to in that piece. I mean, that is correct. I mean, in other words, in the two boxes that I was focusing
Understood.
on. So that's not incorrect.
It's not incorrect, but it's having dismissed, if you like, all the prior answers as well, the way that's framed. And also he then does say it isn't consistent with what's shown by the tick boxes. Or in one of my submissions, that's not right. And then,
I mean, I understand the solutions you made earlier, but had it been intended that this was simply an account opening for trading in CFDs, you might have expected someone to say, I've traded in CFDs for 15 years, if that were the case, rather than I've traded in equity.
well, my lord, I apologise, I may have misled you. The agreement obviously enabled a number of products to be traded. The Ombudsman found that, in fact, at the time that trading occurred, lineal focused on CFDs, but they weren't necessarily, at that point, limiting themselves to the ability to trade other instruments, and that's manifested by the account opening form and the managed account discretionary form. So you can, and they ask questions about everything. That's response 1. And response 2 is that if once he'd given very comprehensive answers about the experience of CFDs, he didn't need to put anything in the box. And he obviously just gave an overview that he had 15 years plus experience with top quality stocks.
And you say, obviously, and when he did come to make his complaint, one thing he didn't say was, hey, they put me into a load of CFDs.
No.
And I had no idea what CFDs were. I was a blue chip equity man only.
He certainly didn't say that. And he also, as a professor at LSE, signed a declaration that everything he said in the form was true.
Yes,
And
but that's a different point.
yeah,
The point I was asking about is the Ombudsman's provisional conclusion that if you're going to trade in CFDs, saying you've got experience of trading doesn't really go with the knowledge and experience. And when one looks at 3.5.3, it's the reasonable assurance in the light of the nature of the transactions or services envisaged. So it may be relevant as to what was envisaged at the time the form was opened. I entirely accept the account opening form enables you to do anything.
yes.
But that's not the same as what was then envisaged.
But
If
my
you-
lord, I can completely understand that point. But the form asks for very specific details of contracts of difference.
yes.
And you tick the top answers, i.e. I am one of the most experienced people. And then the criticism that's made ignores that answer or says it's not consistent with one of the two. The answer on page 38, have invested for plus 15 years in blue chip stocks. And I've already addressed you on that that isn't saying I've traded equities for 15 years. If it said that, then I can see the point. What it was saying was shorthand for the type of trading I have done is in relation to the very best companies for 15 years. And that could have covered CFDs or equities. So it's not...
I mean, the word investment is capable, you say, of covering CFDs and blue chip stocks.
Exactly. It doesn't use the word equities. If it said equities there, it was read as equities, but what I've shown you is that's inconsistent with even what Professor Wilcox did, so it can't be the right reading of that phrase.
The question is whether it
Is
was
enough.
the question is whether it should have raised an alarm bell as to what he really meant by it.
Well, my lord, I think it follows. You see that the answers, with the warning that was given at the top of the form saying you have to give truthful answers, which you'd assume if you were filling in any form, you then have the specifics on CFDs, and he's answering market knowledge I don't think it would. I think the alarm bells might come if he said, I focused on equities for the last 15 years. Or if he ticked no to, I've never traded in CFDs. Or possibly if he'd actually said, I've only done 1 to 39. Then, at that point, there would have been reason to say, well, on its face, is this enough? And he might have not even had further inquiries. He might just have been rejected.
Yes, I see.
Then, my lord, can I just show you page 148? I'm sorry, I'm slightly rushing. I just want to show you a case as well. This is still the provisional decision, but the reason I'm showing it is that this is where the Ombudsman addresses the filling in the form. And he says at the bottom 3 paragraphs, he provided the wrong information about his previous investment experience. I think that was key to Linear treating him as an elected professional client, which is right. And I asked him why. He said he was unsure, but said it could have been shares. I've considered this, but I'm not persuaded that that provides a satisfactory explanation. And then if I let you just read down to the following 6 paragraphs or so. And on that basis, he makes a 25% reduction at that stage. Now, he issues the second provisional decision in February 2022, and that's largely adopted verbatim in the final decision, which is in the core bundle at tab 16. And may I show you that? And as I said, I want to show you, I think, at least one case, if I may. I've shown you this.
So you're going to the core.
Core bundle, tab 16, please. It's the final decision. So, my lord, you see that the history is recited the first few pages. And you see the tick box language comes really from the investigator at paragraph 6, as is acknowledged. And then 8, use of checklist. Didn't go beyond from self-certifying. Now, it was unclear, really, this was a sentence, I think, on a judge, but Justice Snowden had in mind at the end of 8, he thought it should have checked how the professor's job would have provided him with the experience of the transaction. It's just not clear why that would have been necessary on the rules. And he didn't think that the tick box indicating 2 years of experience was enough. And then if we go over then, please, to 231. That's where the decision starts of should Mr. W have been categorised as an elected professional client. And the Ombudsman sets out everything. And the relevant passages start at page 234 of the bundle from about paragraph 39. And again, this language of tick box answers, I mean, they work physically, boxes, but it doesn't denude the content and the fact that they were representations as to the truth of those matters. And again, you see in 42, he just had to tick. But I think that may be in contradistinction because there's less experience needed, but it does seem dismissive, if I may say so, that language. And then 43 and 44. And I think my Lord Justice Snowden asked me about my second error, about the fact that the introduction of the requirement for independent evidence, and you asked me to ground it in paragraphs of the decision. And so this is one of those paragraphs, paragraph 44. And 47. And then at 48, he relies on the supporting evidence, which I've addressed. And 49, he says that should have put him on notice. And there's mention, although this isn't in the bundle, and I haven't seen it, about a different account opening form with different information, but it doesn't appear to be relied on here.
I mean, I'm not clear whether the Ombudsman says, as a matter of law, the boxes which are required to tick aren't good enough, because it never or whether he's saying, on the facts of this form, they're not enough, because the form itself indicated that further evidence would be required by Linear, and no such evidence was provided.
Well, I think he's saying in 43 to 44, but particularly 44, that it's as a matter of law, but 47 is on the facts of this case. Certainly the second half of 47. 44 seems to be saying that I know that tick boxes are used, but I don't think they amount to much more than self-certification. I don't think that tick box answers alone, and I don't think that's based upon.
I mean, could he be wrong on 43 and 44, but right in relation to 47 and 48?
Yes, I accept it's a different point. I accept that if he found on the facts of the form that more was required, that's different from the error of law. But I would say that you could find the error of law, but find it would have made a difference. But the fact is, I've addressed those factual points separately, insofar as they are distinct. And if you remember, my Lord, I said at the outset when you asked me, is it on every form or on this case, and I gave you the answer both, and that's what I had in mind. And if you look at 57, my Lord, which is on page 236, that's similarly, seemingly. Now, here I would suggest to you that this, in answer to my Lord Justice Nugee's question, is how we say, and you can see it very clearly if you went through the investigator's process where he sought to establish the truth before reaching the conclusion. And that, we say, infected the whole approach. But you see that he says in 57, it didn't try to test the information. Well, there was no need to test it if the answers were sufficiently conclusive. And then he says he hadn't previously traded CFDs, effectively, he says in the first 3 lines. So in the circumstances, if Linear had sought further evidence, I don't think he would have been able to provide this. Therefore, they wouldn't have been able to satisfy the test.
You skipped over, there was 51, I was confused a little bit by 51 and 52.
Yes.
Where the Ombudsman appeared to say that there was some other inconsistency.
That's right. He seems to be relying on some other form that isn't part of this process. It's not in the bundle. I haven't seen it. So I don't think it's relevant. But even if you took what it says on face value, it's not obviously inconsistent because he may have had experience in the financial sector at some point.
Okay, but we don't have that.
But we don't have it, and it isn't, as I understand, a point relied upon.
I haven't quite understood the point you were making on 57 and 58.
What I'm saying is that his answer to, if you read 57 and 58, my lord, in the context of the Ombudsman's finding that he thought that there was no relevant CFD trading, he appears to be saying, influenced in the suggestion that further evidence should have been obtained because, had it been sought, it couldn't have been provided.
No, I mean, just reading those two paragraphs on their own, he's already made a decision by the time he gets to 57 that the information they had wasn't enough to mount an adequate assessment, so they should have asked. And then in 58 he's saying if they had asked, because he hadn't in fact got any experience, he wouldn't have been able to give them any evidence of experience, so they would have concluded that he didn't satisfy the test. Well, that's just a causation.
I understand that, but there are 2 points on this. First of all, the question of whether or not he had the relevant experience wasn't relevant.
But it's obviously not relevant to the question whether they should have asked, but it is relevant to the question what answer they would have got if they had asked. Now, I don't read 57 and 58 as saying any more than that. The conclusion in 57 that the tick boxes weren't adequate doesn't seem to me to depend in any way on what his actual experience was. It depends on what he thinks is an inconsistency between saying I've got experience and then saying I've traded in equities for the last 15 years, which is how he reads the blue chip answer. And you say he's wrong about that, but none of that reasoning depends on what his actual experience was.
No, what I think I would just put into play is if he had thought further evidence should as a matter of course be asked for, one would expect him to have said, and what I would have expected to be asked for and provided was as follows. But here, he's really mindful, only gives the example they would have been able to provide nothing without ever actually engaging with the question on the facts as to what exactly, if you don't want tick box answers, what exactly every firm should be doing.
Well, in the middle of 57 he says it didn't try and test this information by making further inquiries and obtaining documents that would have shown whether he had previous CFD experience,
I suppose
such as evidence of previous. I mean, you may or may not say he's wrong about that. You do say he's wrong about that, but I don't want to take up your time. But it doesn't seem to me that he's saying there anything about the fact that the professor did not in fact have such experience somehow generates the duty to make inquiries, which would be to put things the wrong way around.
I think I understand George's point. I think that I am influenced by this, seeing how the investigation focused very much on the truth.
Okay.
But what I would say is that it's not very clear on the Ombudsman's paragraph 57 what further inquiries and what further documents could have been obtained to show the previous CFD experience. Is he saying that he would have just wanted one to demonstrate that he was telling the truth? Is he saying that they needed to show the frequency or all of the history for the 2 years? Or which type of trades?
Sorry, Tony, but isn't 58 simply just underlying the fact that if they'd asked for anything, they would have got nothing?
Yes, but the prior question is, given this is for every single client who simply wants to trade in these stocks, the level of inquiry that's said to be necessary as a matter of course. It's being said that provision of information through tick boxes isn't enough and you have to test it all. Now, can I just show you, because I'm very mindful of the time, the Wilson case, because that may put in context why I'm making the submissions quite in the way I am. And yes, I mean, my learned Jay is just making the point that 58 comes before 59 as part of the satisfaction of not satisfying the point of the test. Now, if we could turn to the case of Wilson, which is in fact 6 of the first authorities volume. In this case, Mr. Wilson traded CFDs, futures, options, and engaged in spread betting. And he made losses and then sought to recover them from the defendants. And you can see that in paragraphs 1, 2, 3. And one of the core allegations advanced was the failure to classify him correctly under COBS rules that were then enforced. And you can see this. So you see at paragraph 7 on page 211, the regulatory framework is set out. And 21 on page 214 is focusing on the compliance with COBS. And these were in part, the predecessor rules. I think one of them hasn't been repeated, 1.4R. And what is said is that the claimants were wrongly given the classification intermediate customer, which can be read now as professional, elected professional, instead of private customer. And the significance is a lower level of regulatory protection is afforded to intermediate clients. And over the page you see the rules. And 4.1.9R and 10G are the equivalent. So you see the sufficient experience and understanding in 4.19R1, and then over the page you see the equivalents there. I said to my Lord Justice Snowden that the word established had been used in a predecessor rule by way of contrast, and you can see that in 4.14R, but that I don't think has been replicated in that particular rule.
But it's still only an obligation to take reasonable care. It's still not, you have to get it right.
That's right, but you could use the word establish, and it hasn't. That was my point, that it was, that's where I got that word from. Then at paragraph 24, where there's a challenge, the court is not concerned to come to its own separate and objective assessment of the correct classification. The test is whether reasonable care has been taken to determine that the client had sufficient experience and understanding to be classified. And you look at the criteria prescribed. And then if we go over to 28, please, page 217. It seems clear from the evidence that the standards of reasonable care did not extend to setting the client a test or examination to assess his level of knowledge or competence, nor was there any general understanding that his client's statements of fact about himself or his expertise should be tested or doubted. I see no reason why such statements should not be taken at face value unless and until there is some reason to apply further scrutiny. Now, just pausing there, the Ombudsman appeared to be saying that tick box answers were impermissible self-certification, so something further was required. And we suggest that's not right when they are providing statements of fact about the client's personal situation and his expertise. The second point is, obviously, there is the exception of some reason to apply further scrutiny, and the question is, was there a further reason when the form was properly read, or did the tick box element infect the Ombudsman's thinking? Now, if we then look at these at paragraph 37, this is what information they had. It was Mr. Wilson's assessment of a number of factors: more than 2 years' experience in shares, bonds, and funds, frequency of trading daily, average trade; less than 6 months' experience, more than 2 years' experience in commodities; 2 years' experience in CFDs, no information was given as to frequency and size; gross annual income. So the sort of types of questions are obviously got some precedence in other people's types of forms. And it was said here that he wanted a calculable risk in order to achieve a profit. That's 38. And then, if we can then go, please, to 42, so page 221. And the questions being considered. And if you look, please, at 44, you can see here that Mr. Wilson had failed to provide some information, and therefore the defendants had less information in these significant areas than they would have liked. It was thus possible to make only a correspondingly less informed judgment about such matters. They'd asked Mr. Wilson and he declined to answer, so I accept that they'd asked him, but they carried on without that information. And if you look at 45, it is legitimate and indeed standard practice to make a decision about the client's experience and understanding by way of inference from such factors as length of time for which he has been trading, as well as from the frequency and scale of transactions. And they had, if you look back at 44, information about CFDs there. And that's what they had. And it said here, it is appropriate.
Who's Miss Robbins?
Mr. Robbins, I think, was one of the experts.
Defendant's expert.
That's right.
So is he just, he's just reporting her view?
That's right. And we'll come on to the finding. He says he's reporting his view. Short of setting an examination, it is difficult to see how else to come to a conclusion. As to shares and CFDs, it would be reasonable to draw an inference from the scale and frequency of dealing. He would, on any practical assessment, have acquired a good deal of experience and understanding as to the way the markets work, as to the incidence of commissions and dealing charges, and the risks attaching to such trading. Furthermore, in relation to commodities futures, if he'd been trading for more than 2 years, he could hardly be failed to be aware of the risk. Plainly, there would be less experience and less understanding.
Sorry, are you saying this is the judge's acceptance of these propositions, or is he just reciting her evidence?
I think he's accepting the proposition with the short of setting an examination. It's difficult to see how else to come to a conclusion, I think, because that mirrors the wording in 28 of not setting a test or an examination. The paragraph also refers to Mr. Jones' evidence, which is the other side's expert, I think, as well. So I think it's saying what the evidence experts have said and what the judge thinks. And he said, and the judge then says at 46, it's necessary to keep in mind, as I've said, that the test to be applied is not whether the defendant had acquired any particular degree of knowledge about the customer's experience and understanding in any given field of activity, but rather whether they'd taken reasonable care in the circumstances. The guidance did not require the defendants to have to regard to all 4 factors identified, but indicates merely it's likely that a firm will need to have regard to more than one of them. And the state of knowledge is then summarised at 48 and 49, criticisms made of the managers in 50. And then at 52 it is said, it's not an attractive stance from Mr Wilson now to contend that when the defendant had insufficient information for the classification process, in circumstances where the gaps in their knowledge are attributable to his failure to supply the information sought, it's also unattractive for him to place reliance on the fact that he supplied the defendants with information that was inaccurate. And his explanation is then set out. And 55, as I've already indicated, the defendants were entitled to take any claims Mr Wilson made as to his past trading or dealing experience at face value.
Yes, Mr. Barney, I'm very conscious of time. Are you going to finish by 1 o'clock?
I assume I have to, my lord.
Yes.
So I was going to walk it through.
Because you've got grounds 2 and 3.
And I'm going to move to them.
Yes.
But I wanted to show, I thought it was important I showed you this decision. I obviously had to show you the judgment.
Thank you.
And this case and the Spreadex case, and also there is the Bank Lumi decision. And if, while I'm in the authorities bundle, I just simply show you that one as well. It's one paragraph. It's at tab 5, 220. So it's page 523 at the top of the report, or 179 of the bundle. This is the Chancellor sitting as a first instance judge, as he then was. Just cast your eye over that.
Thank you.
And 244, these on page 186. And if you could then go over briefly to 248 at the end, the last sentence, and 249, it was said that further information should have been sought. And 250, just challenging the Ombudsman's conclusion that no information would have been provided. If Professor Wilcox was prepared to lie, who knows what would have been provided. And that's a point that 251 and 252 you might see the same also. And then 259 is the final paragraph. Sorry, 259, 263, I beg your pardon, that's it.
But you're not saying, are you, that the Ombudsman's conclusion on, I think it was 58, that if they should have asked, and had they asked, they would have discovered there wasn't any evidence of trading of CFDs. Are you challenging that conclusion?
Well, I'm saying that his whole conclusion is irrational, and as part of that, it is irrational to say that actually if you'd asked somebody who was prepared to lie, you would have necessarily found out the truth.
Does he actually say he lied?
Well, he accepts that he doesn't, he says that he doesn't accept, I showed you in the provisional decision, that the explanation that
Quite the same,
has, was correct. He said that in the provisional decision, and therefore he's saying that when he ticked the forms, he misrepresented his trading experience. And he signed a representation saying it was true. and he doesn't change that. He changes his finding on contributing negligence, but he doesn't depart from what I showed you in the provisional decision, where he doesn't accept the explanation given by, and doesn't suggest there was any other explanation for it. So he doesn't accept it when he said he
doesn't. Pick up my lord's point. He doesn't expressly say.
No, but there's no other conclusion
I see.
on his findings. He doesn't use the word he lied, but he says this is his explanation. I don't accept that explanation because there are all these problems with it. So what you're left with is no satisfactory explanation for ticking a box representing that he had experience which the court found, essentially, that Johnson found he didn't, and he signed a representation of truth on it, and he is somebody who would understand what it meant.
Yes.
So you're
It
left.
still doesn't follow that had Linear said, could you give us
No.
evidence of a past CFD transaction, he would have manufactured one. I mean, that seems...
Well, I'm not saying it follows that he would have done. I'm saying it's not necessarily the case that he would have not produced any further evidence if he followed that he had already misrepresented the position. That's all I'm saying.
Just let you deal with the other two grounds.
Yes. 5 minutes. Ground 2 deals with the redress point. And the point is actually very simple, and we've addressed it in our skeleton, which is simply that once you've found that, this is on the assumption that ground 1 is upheld, you have to still start from the basis that Professor Wilcox willingly and entirely voluntarily wanted to trade CFDs or sophisticated products on a professional portfolio. And he therefore chose to participate in a programme that invested in particular stocks using a quantitative trading model, which is very different to an index, which is a passive means of tracking a group of assets.
This goes back to the question that I'm still not struggling with to find an answer to, which is where is the finding or the evidence that the professor wanted to trade CFDs? There is a finding in paragraph 50 of the Ombudsman's ruling, quotes, Linear intended trading CFDs with Mr. W's portfolio. That's what the Ombudsman's found. But where is the... Other than the fact that he never said, I don't think he's ever said at any time, I didn't want to trade CFDs. I mean, there's no actual finding anywhere that he always intended to trade CFDs. I mean, I think it's just that he's never said he didn't, and there's an indication that Linear intended to do it, but I just don't have that other piece of the jigsaw expressly, as far as I'm aware.
I think all we can show you, my lord, is that he was told about Linear's portfolio by a family friend and sent its website, that he then applied on the account opening form to trade the products and also signed the managed discretionary
You say it's the inference that even if mischaracterised, he still wanted to trade CFDs.
CFDs or any of the products listed in
but he wouldn't have been able to if he'd been correctly classified. So if the basis upon which we get to ground 2 is that he was incorrectly classified, he wouldn't have been able to trade CFDs.
I understand that, so I'm not suggesting that would be the comparable. What I'm suggesting is that he obviously had more risk appetite.
What are you asking? Do you submit that to other findings?
I think it should be by a different basis in comparison with the near index, for a more appropriate.
You're not putting forward any candidate.
No, I'm not, because I don't have the evidence report. And then the final point is from Nugee.
What's your figure?
And we would say it was between 50 and 75%, because the whole relationship was induced by the misrepresentation. So even if you find that Linear should have been properly and adequately set the real basis is the deliberate misleading, you say, that finding and simply on the but-for test, but-for declarations given, wouldn't have been accepted. But I'm being realistic about it because I accept that Linear would have to bear some responsibility if you found liability on ground one, but it certainly wasn't right to not give any amount, and even if 95% given in the decision, saying there should be nothing based on Ombudsman's own findings would be wrong.
On that one, you would invite us
Yes, I would.
to select the figure ourselves
I would.
if we get to that stage.
And can I just make one point on the law, which you will know, that the Act provides that the damage is suffered as the result partly of his own fault. Now, that's got the authorisation, and it's partly of his own fault, not necessarily entirely of his own fault, but it envisages, obviously, producing negligence, more than one person who's responsible and has caused the loss. You say that's exactly what the law implies. And then, my lord, the final point just generally is on the point of principle that we do say that the Ombudsman's approach didn't give any weight or appropriate weight to the law on signed representations by an individual with the capacity to understand. And it would have been capable of producing a contractual estoppel. And that was ignored in the reasoning of the Ombudsman, and or he didn't give proper reasons for departing from the law. And that's why we say it is an important point of principle, because in his reasoning, the combination of tick-box answers and some due diligence, to put it that way, completely overrode the ability to take account of a signed representation of the truth of the matters and rely on the experience of Professor Wilcox. There are 2 points on that. The first is one of law, which is his reasoning applied generally just on the basis of the tick-box answers, and then separately it was irrational based on the facts. But as you see, the law, even in this context, in the Wilson case and the decision of the Chancellor, is very clear, but the law on representations per se is even clearer.
Well, it's all set out in your scope.
It is.
Thank
Sorry,
you very much. We'll to